The first car came through at 7:18 on a Monday morning. I was standing beside my garage with a mug of coffee when a silver SUV turned off the back street of Cedar Hollow, crossed the narrow strip of grass behind my property, and continued down my driveway toward the county road. The driver slowed when he saw me, lifted one hand from the steering wheel, and kept going. 2 minutes later, a pickup followed. Then, another SUV. By 7:30, 5 vehicles had crossed the property. My driveway was not a neighborhood street. It began at the county road, followed the south edge of my lot, and curved behind my house toward a detached garage. Beyond the garage, an old gravel lane continued toward my rear boundary. Cedar Hollow had been built on the other side years after the house. A line of shrubs and a shallow drainage swale separated my property from the subdivision's back street. That morning, part of the shrub line had been cut away. 2 orange arrows had been attached to temporary posts. One pointed from Cedar Hollow toward the gravel lane. The other stood near my garage and directed traffic toward the county road. At the rear corner of my property, someone had installed a white sign, Cedar Hollow, temporary south exit. The management company's logo appeared beneath the words. I photographed the sign, the arrows, the cut shrubs, and the tire tracks crossing the grass. Then I walked the route from one end to the other. Fresh marks ran through the gravel. The edge of the asphalt near my garage had begun to crumble, where drivers were turning too sharply. A muddy track passed within a few feet of the building. At 8:05, I called the number printed on the sign. The receptionist transferred me to Olivia Kane, Cedar Hollow's community manager. I explained that the association was directing traffic across private property. She did not sound surprised. Olivia said Cedar Hollow's main entrance was undergoing repairs and that the community had activated its southern access route. She described the arrangement as temporary and said residents had been told to drive slowly. I asked what recorded document gave the association the right to use my driveway. She said the community's documents had already been reviewed. I asked her to send me the easement. There was a pause. Then she said the association's lawyer would respond. Before noon, another 11 vehicles crossed the property. Some drivers looked uncertain. Others followed the arrows as though the route had always been there. I did not block the lane. I did not move the HOA's sign or confront drivers. Instead, I parked my truck near the garage, so vehicles had to slow down. I placed 2 cameras facing opposite directions and set a portable private drive sign near the county road. By sunset, I had counted 37 trips. The next morning, an email arrived from Cedar Hollow's management office. Attached was a 1-page neighborhood map. The main entrance was marked closed for gate and pavement work. A dotted line led from Cedar Hollow's back street, crossed the lane behind my garage, and continued down my driveway. The line was labeled Temporary Resident Access. According to the email, the entrance project was expected to last 6 weeks. The message said the secondary access corridor had been part of the community's original development plan. That phrase sounded official. It did not identify the owner of the land, the location of any easement, or the legal scope of the access Cedar Hollow claimed. I replied with 4 questions. What recorded instrument created the right? What parcel did it burden? Who was authorized to use it? What purposes did it permit? I asked Cedar Hollow to suspend the route until those questions were answered. Olivia responded less than an hour later. She wrote that closing the southern route would interfere with the community's traffic plan and cause congestion at the main entrance. She said the HOA had relied on its governing documents and historical use. Historical use had not been mentioned during our phone call. The explanation had already expanded from easement rights to development plans, governing documents, and past practice. I saved every email as a PDF. I photographed the route from both directions and measured the distance between the tire path and my garage. I kept a written vehicle log. When a lawn service truck came through, I photographed the company name and later called its office. The dispatcher told me Cedar Hollow management had included the southern route in the vendor instructions. On the 3rd day, the temporary white sign was replaced by a heavier metal sign attached to 2 posts. The orange arrows were repositioned to make the turn easier to see. This was not a route the association was merely tolerating. It was marking, managing, and promoting it. I also noticed that Cedar Hollow's back street did not line up with the gravel lane. Drivers had to cross a strip of grass and the edge of the drainage swale before reaching my property. The turn was awkward because the old lane had never been designed as a subdivision connection. The HOA map erased that problem. On paper, the route appeared to be a straight, established corridor. I pulled out the closing file from when I bought the property 6 years earlier. My deed described the parcel by meets and bounds. The title policy listed several exceptions, including a utility easement near the eastern boundary. Nothing in the file appeared to grant Cedar Hollow residents a right to cross my driveway, but I knew one closing file was not enough to settle the issue. An easement could arise from an instrument I had not seen, and the absence of a document in my file did not prove that no claim could exist. I needed the recorded history, a survey, and legal advice. That afternoon, I made an appointment at the county recorder's office. I also contacted Marcus Bell, a licensed surveyor, and Rebecca Sloan, a real estate attorney. By the time those appointments were scheduled, Cedar Hollow had begun work at its main entrance. Concrete barriers narrowed the road. A contractor's message board directed outbound residents toward the south exit. My driveway was no longer being treated as an informal backup. It had been built into the project. The recorder's office supplied copies of the documents indexed to my parcel and the surrounding subdivision land. The oldest relevant instrument was a utility easement recorded decades earlier. It allowed named utility providers to install, inspect, repair, and replace equipment within a strip along one side of my property. It did not grant general vehicle access. It did not mention Cedar Hollow residents. It did not authorize the use of my driveway as a neighborhood road. Cedar Hollow's declaration created the association and identified the streets and common areas inside the subdivision. A section titled Access allowed homeowners to use the private roads shown on the recorded subdivision plat. My parcel was not part of that plat. The plat showed Cedar Hollow ending at its back street. Near the southwest corner was a narrow area labeled Future Access Parcel B. The developer had owned Parcel B when the plat was recorded. It touched Cedar Hollow, but it did not extend to the county road. My property stood between Parcel B and the road. The map Olivia had sent me treated Parcel B, the old gravel lane, and my driveway as one uninterrupted access corridor. The recorded plat showed 3 separate areas. Marcus was careful when I gave him the documents. He explained that he could locate the recorded boundaries and easements, compare them with physical conditions, and prepare a survey. He could not decide whether Cedar Hollow might have an unrecorded legal claim. That would require legal analysis and, if the dispute could not be resolved, possibly a court decision. Marcus spent most of the following Thursday in the field. He located 2 old iron pins, measured from recorded control points, and marked the subdivision corner. His preliminary measurements placed the gravel lane entirely inside my property. Cedar Hollow's back street ended several feet beyond the boundary. Vehicles using the temporary route crossed the grass and drainage area before reaching my lane. The secondary access corridor, shown on the HOA map, was not a surveyed feature. It was a line drawn across separate parcels. Rebecca reviewed my deed, the plat, the title policy, Cedar Hollow's declaration, and the emails from management. She warned me not to claim that an easement was impossible. The records we had found did not show a recorded residential access easement, but the association might rely on a prior agreement, historical permission, or another legal theory. She also advised me not to place a barrier across the route without notice. Drivers had been actively directed onto the property, and an unexpected obstruction could create a new safety problem. Instead, Rebecca sent a formal written objection. The letter identified my deed, attached the relevant plat pages, and stated that our search had not located a recorded instrument authorizing Cedar Hollow residents to cross the property. It asked the HOA to identify every document and legal theory supporting its claim. The letter also demanded that Cedar Hollow stop directing general traffic across the driveway while the claim was reviewed. The HOA was given 5 business days to respond. 2 days later, Olivia forwarded a letter from the association's lawyer. Cedar Hollow was not withdrawing the route. The lawyer did not argue that the utility easement permitted residential traffic. Instead, he said Cedar Hollow had been designed with 2 access points. According to his letter, the southern route appeared in planning materials, had been used during development, and had been recognized by a former owner of my property. The association believed it held continuing access rights, whether those rights arose from a recorded instrument or from the history of the land. That was the first detailed legal position I had received. Rebecca requested the planning materials, any agreement with the former owner, and all records showing when the route had been used. She asked for maintenance invoices, contractor instructions, board minutes, correspondence, maps, and any evidence that Cedar Hollow had treated my driveway as association infrastructure. While we waited, traffic continued. During the evening rush, cars arrived in clusters. Some slowed when they saw the private drive sign. Others followed the HOA arrows without hesitation. A delivery van left the asphalt and deepened the rut beside the drainage swale. One driver had to reverse near my garage after meeting an oncoming vehicle. I sent the photographs to Olivia and repeated my request that the route be suspended. She replied that drivers had been instructed to use caution. She also wrote that the route was necessary to keep the main entrance project on schedule. The following morning, 2 maintenance workers moved one of my signs. My camera recorded them arriving in a truck carrying the management company's name. They shifted the private drive sign away from the travel path and installed another orange arrow. I did not approach them. I saved the video, photographed the new placement, and gave the material to Rebecca. She sent a preservation notice directing the association and management company to retain project emails, traffic plans, vendor instructions, board communications, and surveillance footage. Later that week, I attended an open Cedar Hollow board meeting as a guest. Olivia presented the entrance project. Her report covered the contractor's schedule, gate work, pavement removal, traffic control, and resident complaints about delays. When a director asked about the southern exit, Olivia said the association's lawyer believed Cedar Hollow had a defensible access position. I was given 3 minutes to speak. I explained that the marked route crossed land outside Cedar Hollow's recorded plat. I said Marcus's preliminary fieldwork placed the gravel lane inside my property, and that the association had still not produced a recorded instrument granting general residential access. I asked the board to pause the route until the easement review was complete. The board president said council would address the property issue. The next morning, Cedar Hollow sent a new traffic notice to residents. South exit remains open, it said. Please follow posted signs and observe the reduced speed. By then, the association had received my written objection, the recorded plat, notice of the survey, and photographs of the damage. It still chose to direct vehicles across the property. Cedar Hollow's strongest public explanation was safety. Residents needed a dependable exit while the main entrance was under construction. Delivery vehicles needed room to move. Emergency access could not be disrupted. Rebecca separated that argument into 2 questions. Had any public authority approved my driveway as part of Cedar Hollow's emergency access system? And even if a southern connection had once been discussed, did that discussion create a permanent private right for ordinary residents? I requested the entrance work permit file from the county planning office. The file included a traffic control diagram submitted by Cedar Hollow's contractor. The main entrance was shown under phased construction. A note on the plan read, "Maintain secondary resident access at south connection." The county had reviewed a construction plan that assumed the southern connection was available. The file did not contain my permission, a recorded easement, or a survey showing that Cedar Hollow possessed rights across my parcel. Planning staff had reviewed traffic management for the project. They had not decided who owned the driveway or whether the association held an easement. The fire marshal's office provided a limited response. Cedar Hollow had internal fire lanes and an approved primary entrance. The office had not designated my driveway as a required fire apparatus road. That response did not decide the property dispute. It did remove the suggestion that a fire official had ordered the HOA to turn my driveway into a routine exit. Rebecca sent both responses to the association's lawyer. She proposed a temporary solution. Cedar Hollow could maintain one controlled lane at the main entrance, divide the work into smaller phases, and stop directing general traffic across my property while the documents were reviewed. The proposal did not attempt to interfere with emergency officials acting under lawful authority. It addressed the ordinary resident and vendor traffic the HOA had created. Cedar Hollow rejected it. The association's lawyer said the entrance project would become more expensive and take longer if traffic had to remain at the main gate. He also wrote that Cedar Hollow would not abandon a right simply because I disputed it. That answer clarified why the southern route mattered. The project could be completed without my driveway. It would require more flaggers, shorter pavement sections, and a revised schedule. The shortcut was not the only possible way to perform the work. It was the cheaper and faster way. During the first 9 days, my cameras recorded more than 400 vehicle movements. Gravel had migrated toward the swale. The asphalt edge continued to break down. Tire marks crossed the lawn. I obtained a repair estimate from a paving contractor and a separate drainage estimate. Those estimates did not establish legal liability. They documented the condition of the property while the traffic was continuing. Near the end of the second week, Marcus called to say his survey was complete. The recorded utility easement was located where the old instrument placed it. Cedar Hollow's marked traffic route crossed a different part of the property. At almost the same time, Rebecca found a reference in an archived county file to an agreement that neither side had yet produced. The file contained meeting minutes from Cedar Hollow's original development review. One paragraph discussed temporary construction access from the south. The developer had proposed using an existing farm lane so heavy equipment could avoid the future residential entrance. County staff noted that the route required separate permission from the neighboring owner. The minutes also stated that the permission was not part of the subdivision approval. A later inspection report confirmed that a southern construction route had been used. After Rebecca cited those records, Cedar Hollow produced a 2-page letter signed by the former owner of my property and the subdivision developer. The letter granted temporary access over the farm lane for subdivision construction. It allowed contractor vehicles and equipment to enter from the county road until the subdivision streets were substantially complete. It did not grant access to future residents. It did not describe a permanent secondary entrance. It did not transfer rights to the HOA. The letter also required the developer to restore the lane after construction. Cedar Hollow's lawyer responded that the letter was only part of the history. He said the lane had remained physically open and had later been used by maintenance vendors. The association reserved the right to argue that later use confirmed or expanded its access rights. Rebecca requested the supporting records. The association produced several landscaping invoices and a utility contractor's work order. The documents showed occasional vendor use near the southwest corner of the subdivision. They did not show that the former owner had granted Cedar Hollow residents a permanent travel right. Cedar Hollow's reserve study did not include my driveway. Its road maintenance budget did not identify the lane. There were no records showing that the association had resurfaced my asphalt, maintained the drainage swale, or insured the driveway as a common road. Marcus finalized his survey. It showed the property boundary, the recorded utility strip, the visible gravel lane, and the end of Cedar Hollow's back street as separate features. His notes identified the instruments he had used. They also made clear that his survey located the recorded rights and physical features. It did not decide the association's unrecorded legal theories. Rebecca then completed a written easement review. Her conclusion was narrow. The located records did not establish a recorded easement for general residential access. The temporary construction letter supported a limited historical permission for a different group of users and a different purpose. Cedar Hollow could still assert other legal theories, but those theories would require more than the dotted line on its traffic map. 3 weeks after I first saw the white sign, the association filed a civil action. Cedar Hollow asked the court to declare that it possessed a continuing right to use the southern route. It also requested temporary relief preventing me from blocking access while the claim was pending. The complaint described the route as long-standing, necessary, and recognized through the property's history. The filing proved that the association had made those claims. It did not prove that the claims were correct. The first hearing took place 11 days later. The judge said the available record was not sufficient to decide whether a permanent easement existed. Cedar Hollow relied on the temporary construction letter, the archived planning references, the physical lane, and declarations describing vendor use. We relied on my deed, the subdivision plat, Marcus's survey, the vehicle records, the damage photographs, and the written objections sent before the HOA expanded its traffic instructions. Cedar Hollow asked for an order, allowing the route to remain open throughout the litigation. Rebecca argued that the association was trying to turn a recently created residential traffic pattern into the status quo. She said the route had not functioned as a neighborhood exit before the entrance project, and that continued use would increase the burden on my property. The judge did not grant Cedar Hollow the broad temporary order it requested. Instead, the court recessed and directed both sides to discuss a short interim arrangement while an accelerated evidentiary schedule was set. Rebecca explained my options. I could refuse, and ask the judge to decide the immediate request that afternoon. Or I could agree to tightly limited use for 14 days, without conceding that an easement existed, while the association produced the records supporting its claim. I agreed to the limited arrangement. For 14 days, Cedar Hollow could send passenger vehicles through during two 90-minute weekday windows. The route could not be used by contractors, vendors, delivery trucks, or construction equipment. The association had to provide a traffic monitor, install reflective speed markers, submit proof of liability insurance, and post a bond against physical damage. The written stipulation said the arrangement did not create, recognize, or expand an easement. It also expired automatically unless the parties agreed otherwise or the court entered a new order. The traffic dropped immediately. It did not disappear. Every morning, a monitor arrived before the first window and placed cones at the rear connection. Cars passed during the authorized period. When the window ended, the cones were removed. Drivers who had learned the route still appeared at other times. I sent those recordings to Cedar Hollow's lawyer rather than arguing with them at the gate. The financial pressure grew on both sides. I had survey bills, legal fees, and repair estimates. Cedar Hollow was paying for monitors, additional traffic control, and litigation. The entrance contractor could no longer send equipment through the southern route. During the 14-day period, the association produced project emails, board minutes, contractor proposals, vendor instructions, and management records. Most of the older records mentioned the southern lane only occasionally. A landscaping company had used it to reach a difficult corner. A utility crew had entered during one repair. There was no record of the lane functioning as a regular resident exit before the current project. The more recent project file was different. 4 months before construction began, the paving contractor had warned Cedar Hollow that closing the main entrance would require either a temporary bypass or a longer phased schedule. Olivia had replied that the community possessed a secondary outlet at the south end. Based on that representation, the contractor prepared a shorter and less expensive traffic plan. A later board email asked whether the southern access had been confirmed. Olivia responded that it appeared on the original development materials and had been used during construction. The temporary construction letter was not attached to that exchange. The legal distinction between construction use and permanent residential use was not discussed. The same assumption then appeared in the contractor plan, the county permit file, the resident map, and the vendor instructions. Until I objected, nobody involved in the current project appeared to have asked whether Cedar Hollow's expected route actually reached the county road through land the association had a right to use. That discovery changed Rebecca's approach. Proving that the driveway lay inside my parcel was important. It was not enough by itself to stop the project from continuing to rely on the disputed route. The immediate question was whether the contractor and permit reviewer should continue treating the southern connection as available when the underlying right had not been established. Rebecca first contacted the paving contractor. She provided Marcus's survey, the temporary construction letter, the pending complaint, and the court stipulation. Her letter did not ask the contractor to decide the easement claim. It asked the company to identify which parts of its work plan depended on Cedar Hollow providing lawful access. The contractor responded 4 business days later. Its project manager confirmed that the original price and schedule assumed Cedar Hollow would provide the southern route. Because that access was disputed and restricted, the contractor would perform no work from my property. The company submitted a change proposal for additional flaggers, smaller paving sections, temporary signals, and 9 extra working days. The proposal added $18,750 to the project. That response became the main practical reversal in the story. The contractor had not declared that I owned every disputed right. It had simply refused to continue relying on an access assumption Cedar Hollow could not presently guarantee. Rebecca then sent the survey and the revised contractor proposal to the county planning office. County staff asked Cedar Hollow to update the traffic control diagram so it no longer showed the southern route as an approved resident connection. The county did not determine title. It corrected the part of the permit file within its responsibility. Several weeks later, Cedar Hollow's insurer requested project communications and property records after receiving notice of the claim. The insurer did not cancel coverage, decide liability, or order the HOA to settle. It reserved its position and continued reviewing the matter. That letter created additional administrative pressure, but it was not the event that stopped the route. The contractor's revised plan did that. At the next board meeting, the directors discussed whether to accept the change proposal. The minutes later produced in the case recorded two different positions. Several directors favored ending use of the southern route and completing the entrance project under the revised plan. Olivia told the board that abandoning the route might affect Cedar Hollow's litigation position and increase project costs. The board voted to accept the revised construction plan. It did not withdraw the easement claim. Cedar Hollow would finish the entrance without using my driveway for contractor access. The association would continue litigating whether some broader right existed. The 14-day traffic stipulation expired that Friday. Cedar Hollow asked the court to extend it. At the second hearing, Rebecca argued that the association no longer needed my driveway to complete the project. The contractor had submitted a workable alternative, and the county had accepted a revised traffic control diagram. Cedar Hollow said limited passenger use would reduce congestion and protect the schedule from further delays. The judge declined to extend the temporary arrangement. The court did not make a final ruling on the easement claim. It found only that Cedar Hollow had not shown a sufficient need to continue imposing resident traffic on the disputed route while the case proceeded. The order prohibited the association from directing residents, vendors, or contractors across my property. It did not restrict emergency officials acting under lawful authority. That afternoon, the traffic monitor removed the cones. The metal south exit sign came down. The paving contractor installed temporary signals at Cedar Hollow's main gate and divided the remaining work into shorter sections. The project took longer than originally planned. The added cost was paid through Cedar Hollow's project funds. It did not become a payment to me. By then, more than 7 weeks had passed since I first saw the SUV beside my garage. The legal case continued after the driveway became quiet. Over the next 3 months, both sides exchanged documents and took depositions. Cedar Hollow hired its own surveyor. His work agreed with Marcus on the recorded boundary and the location of the utility easement. The dispute was no longer about where the documents placed the lines. It was about whether the history of the land created a broader, unrecorded right. The former owner of my property was deposed. He confirmed that he had allowed the developer to use the farm lane during subdivision construction. He remembered heavy equipment, gravel trucks, and occasional service vehicles. He did not remember granting future residents permission to use the driveway as a second neighborhood entrance. The developer's former project manager also testified. He said the southern route had been useful during construction. The permanent community design was expected to rely on the main entrance unless another access agreement was completed later. No later recorded agreement had been located. Cedar Hollow relied on the visible lane, the planning references, and the occasional vendor use that followed construction. Rebecca focused on the difference between limited permission and a permanent right serving every home in the community. The county planner testified only about the permit process. The county had reviewed the traffic control diagram on the assumption that Cedar Hollow possessed the private rights required to use the route. Approval of the construction plan had not created those rights. 5 months after the lawsuit was filed, the entrance project was complete, and Cedar Hollow's main gate was fully open. The association still had a pending easement claim, but it no longer had an operational reason to use my driveway. The board then authorized a separate review of how the southern route had been included in the project. The review did not investigate a crime. It examined project controls, document verification, and the management company's handling of the access question. According to the final report shared with the board, the project team had relied on an old planning reference without first obtaining the underlying agreement. The temporary construction letter had not been reviewed before the route was placed on the contractor plan. The report also found that management had continued presenting the route as available after receiving notice that the legal right was disputed. The management company submitted a written response. It said Cedar Hollow's historical materials reasonably suggested that a southern connection existed, but acknowledged that the scope of the underlying permission should have been confirmed earlier. The board adopted new project review requirements. Any future plan involving land outside Cedar Hollow's recorded common area would require identification of the owner, a current survey when necessary, written authorization, and legal review of the exact right being used. The board also asked the management company to assign a different manager to the community while the dispute was being resolved. The company reassigned Olivia the following month. No court found that she had committed fraud. No licensing agency disciplined her. The reassignment was an operational consequence, documented in the management company's notice to the board. The easement case still had to be resolved. I sought a declaration that Cedar Hollow had no general residential, vendor, or construction access right across my parcel. I also sought compensation for the documented physical damage and part of the professional costs caused by the dispute. Cedar Hollow maintained that its historical use claim remained legally viable. The judge ordered mediation. By then, almost 7 months had passed since the first car crossed the driveway. The mediation lasted most of one day and continued through written proposals during the following week. Cedar Hollow did not admit intentional wrongdoing. The court did not issue a finding that the association had acted fraudulently or maliciously. The settlement resolved the access claim without either statement. Its practical terms were specific. Cedar Hollow agreed to execute and record a release and quit claim of any asserted general residential, vendor, or construction access interest across my parcel. The document would identify the affected property and state that the association claimed no right to use the driveway as a community entrance or exit. The existing utility easement remained unchanged. Utility providers could continue exercising the rights granted in the recorded instrument. Emergency officials could act under whatever authority applied to an actual emergency. The association agreed to remove every remaining traffic marker connected to the route. It could not include my driveway on resident maps, vendor directions, project plans, or community access instructions. Cedar Hollow also agreed to pay for repairing the damaged asphalt edge, rebuilding the drainage swale, replacing displaced gravel, and replanting the shrubs cut during installation of the route. The association would reimburse $14,200 of my documented survey and legal expenses. That amount was negotiated in settlement. It was not a damages award entered after a trial. In exchange, I agreed to dismiss my counterclaims after the recorded release was accepted by the county recorder, and the restoration funds were placed in escrow. The parties also agreed on a physical access control plan. A solid wall would have interfered with drainage and complicated utility work. A low chain could be difficult to see at night. Marcus worked with the utility representative to locate 2 reflective posts and a lockable swing gate outside the recorded utility corridor. Utility companies received a controlled procedure for requesting access. Cedar Hollow did not receive a key. The release and quit claim were recorded first. The county recorder did not decide the easement dispute. The office accepted the signed instrument into the land records, creating a public record of Cedar Hollow's relinquishment of its claim. The restoration work began 9 days later. Contractors removed the remaining signposts, repaired the broken asphalt, rebuilt the swale, replaced the gravel pushed into the grass, and prepared the damaged planting area. The work took 4 days. The new shrubs went in on a Thursday morning. By afternoon, the exposed strip between Cedar Hollow's back street and my gravel lane had been replanted. The swing gate stood behind the garage, visible enough to stop a mistaken driver, but positioned away from the road. A small sign on my side read, "Private Drive, No Through Access." There was no HOA logo beneath it. Cedar Hollow's main entrance had been open for several months. Residents were using the gate the subdivision had been designed around. The contractor's message board was gone. The temporary traffic maps had been removed from the community website. I kept the cameras. Not because I expected the association to return, but because the experience had changed how I viewed ordinary property records. A line on a plat can seem abstract until someone posts an arrow across it. A temporary permission can sound permanent when the original document is missing from the conversation. A county-approved project plan can look like proof of property rights even when the reviewer assumed those rights had already been secured. No single person who helped me had the authority to answer every question. Marcus located the boundaries and recorded easements. Rebecca evaluated the legal claims, preserved the evidence, and challenged the association's interpretation. County staff reviewed the construction plan within their own role. The contractor decided whether it was willing to rely on disputed access. The court controlled temporary use while the legal claim was pending. The recorded settlement created the final cure. What protected the driveway was the sequence. The photographs established how the route had been marked and used. The deed and plat established the recorded property layout. The survey placed the paper boundaries on the ground. The temporary construction letter explained the old lane without turning it into a permanent neighborhood road. The project emails showed how an assumption moved from management into the contractor plan. The permit file showed what the county had reviewed and what it had not decided. The court orders preserved the dispute without pretending to settle it early. The release prevented Cedar Hollow from reviving the same access claim after the project was over. The association had wanted to keep the entrance work moving under its cheaper original schedule. Instead, it lost the shortcut, paid for the revised plan, funded the restoration, reimbursed part of my professional costs, changed its project review rules, and accepted a recorded restriction that made the same mistake harder to repeat. I regained the physical driveway. I also regained control over who could use it and for what purpose. A few days after the shrubs were planted, I stood beside the garage at 7:18 in the morning. It was the same time I had noticed the first silver SUV. No vehicles came through. There were no orange arrows, no traffic monitor, and no metal sign calling my driveway a community exit. Beyond the closed gate, Cedar Hollow's back street ended, where its recorded plat said it ended. My driveway continued toward the county road. This time, nothing on the ground suggested it belonged to anyone else.